Good afternoon, all. Welcome to the Appellate Division First Department. We have oral arguments for today, March 20th. We are seated as a panel of four. However, our fifth judge is Justice Kapnick, who, as you can see, is here virtually. When I call your case, please ask for the time that you actually need to get out, only the salient points of your arguments. Please keep in mind we have read your briefs. We are fully familiar with the briefs, with the arguments. The red light is for you, not for us. If we have any additional questions, we will certainly pose them to you. People v. Kenneth McCrae. 5, 2, and 5. Turner v. New York State Office of Court Administration. 5, 1, and 2. Matter of HB Children, that matter is submitted. People v. Michael Webb. 525. Harmon Becker Auto versus Avnet. 626. Siguencia versus the City of New York. 525. Matter of Jamila and Lonnie. That matter is submitted. Griffin versus Abid. 515. State of New York versus Amazon.
Your Honor, for Best Buy, Target, and Adorama, we request 5 minutes. Your Honor, the Amazon is
So that's 6 and 2, 5, and you requested 5? And 5, thank you. People v. Gustavo, Gilon. 525. Barber v. Roman Catholic, the Archdiocese of New York. 414. Justice Kapnick is recused on that matter. St. Mark's v. Morgan. 525. First matter for argument, People v. Kenneth McCrae. Whenever you're ready.
Good afternoon, Your Honor. My name is Paul Wiener, appearing for Appellant Kenneth McCrae. I'd like to start with the suppression issue. The only description that the detective had was blue jeans, red sneakers, and a black jacket. There was absolutely no information whatsoever about gender, race, height, weight, etc. And Mr. McCrae did not even match this bare description.
You say he didn't match. Are you saying that he didn't have the black jacket on?
The detective didn't testify that he had the black
He
jacket.
did testify that the blue jeans and the red sneakers were consistent, correct?
That's correct, Your Honor.
And when the arresting officer went in after the call, that was within 1 minute of getting the radio run of a positive buy, correct?
That's correct, Your Honor.
And was anyone else present at that location who matched the description other than the defendant?
There were three people who were stopped for this confirmatory identification.
So my question was, did any of the 3 people who were stopped match the description given? Did any of them have the red sneakers, blue jeans?
They presumably did, because I don't think they would have been stopped and held for confirmatory identification.
Wasn't the arresting officer or the stopping officer just being careful to be sure before they did the confirmatory identification?
But they needed reasonable suspicion, and they stopped 3 people, presumably because all 3 people or large.
But what we're concerned about is the reasonable suspicion of the defendant.
Right, but the fact that they stopped 3 people meant that they really didn't have a good sense of who.
But that's not what the testimony was. I thought the officer stated that he did not recall what the other 2 people looked like.
Right, but presumably they weren't.
You keep saying presumably. That's like the 4th time you say presumably. Presumably. That's not what the record indicates. That's not what the testimony is. So presumably, we don't know why these other individuals were stopped, and apparently, according to the record, the other individuals who were in fact stopped did not match the description.
Well, we don't know we don't know whether they match the description or not because
We know your client fit the description, and he was with two other people.
right. But again, I think we have to assume that everybody largely
What if
matched
two
the
people,
description,
what if two people matched the description? Would they not be allowed to stop the two people to do the identification by the purchasing officer?
Well, I think that would put into question whether they had reasonable suspicion. Of course, here we had three people. Plus, again, the description was so bare, we don't know anything about.
Yeah, but it's 1 minute later. You know, if it's 10, 15 minutes away and you're in some busy area, maybe that's an argument that carries some weight. But this is like just a minute later.
But if the people are arguing that the most salient part of the description, they're conceding that blue jeans is meaningless because everybody wears blue jeans, and the detective didn't testify that my client had a black
Well,
jacket.
not everyone wears blue jeans and red sneakers.
So they're saying that it really comes down to the red sneakers and the location, and the red sneakers are the so-called distinctive feature. But again, I think there's a good chance that all three of these people may have had red sneakers, in which case, at that location,
On
at
this
that
record, that's
particular
just
time,
speculation, right? There's nothing to substantiate that on this record.
except that they were stopped for confirmatory
But to
identification,
the
which
extent that there was a violation of the constitutional rights of the other two individuals that were stopped, how does that relate to your client?
because it goes to the fact that the police didn't have a good sense of who may have committed this crime.
But ultimately, was there confirmatory identification of your client?
There was a confirmatory identification, but the question is whether they had reasonable suspicion to detain him for 10 minutes. If I could just move on to the second issue, Your Honors. The court responded incorrectly to a critical note in a case in which the jury repeatedly leaned towards acquittal during deliberations. The note asked a very specific question about the distribution of the pre-recorded buy money, namely, is there evidence/testimony that indicates the serial numbers of the money distributed to undercover 72 versus undercover 39 after the tactical
Did
beat?
Exhibit 4 reflect the serial numbers?
Excuse me?
Did Exhibit 4 reflect the serial numbers?
Exhibit 4 contained all of the serial numbers of the
Of all of the money?
all of the money.
And did Miro circle the money which went to the undercover 72?
Yes, Your Honor. But here's the problem. There are actually two problems with that. First of all, Miro did not distribute the money to undercover officers. Miro gave $120, which was all the money that was used in the operation, to undercover 72, and it was undercover 72 who distributed the money.
But we're talking about the jury note. We're talking about what the jurors requested and what the jury requested and whether or not that information was supplied to them. So was that information not supplied to them by drawing their attention to Exhibit 4 and 5?
No. Well, first of all, the jury had already requested this exhibit before, so they obviously didn't want it again. But second of all, as I was saying, Detective Miro wasn't the one who distributed the money to, it doesn't answer the question because he didn't distribute the money to
Didn't the
undercovers.
judge say, if this doesn't answer the question, give us another note?
But there's no reason to clarify here. The note is very clear. The other thing is, we don't know when he circled this. It could have
But
happened.
none of that matters. What is at issue is whether or not the court's response to the jury note was sufficient, whether or not it met the requirements as to what the jury was asking. And again, as my colleague stated, the judge also said, you know what? If this is not what you want, then let me know. Send me another note and for further clarification in terms of exactly what you want. But you have time on rebuttal.
Thank you.
Good afternoon, Margaret Crookston for the People.
People, how do you respond to your adversary's argument regarding jury note number 4?
So the jury note was accurate. The note itself asked, is there any evidence/testimony which indicates how the money was distributed between the two undercover officers? And there was, because the undercover officer had said that he kept 30 for himself, gave that 30 during the buy to the defendant. When the defendant was apprehended, the money was recovered on him by Detective Miro, who then circled that on the photocopy. So that allowed the jury to then make the inference that that $30 was the $30 that undercover officer 72 had kept for himself. So in that fact, it was correct and was meaningful to say that, to direct the jury to those two exhibits. The fact they had asked for those, had already had those exhibits, they had asked for 3 exhibits, they had sent 4 notes within the first 3 hours of deliberation. They heard a lot of readback of the testimony, so they were very inquisitive, and I don't think it's reflective of them being zeroed in on this issue so much as requesting a lot of information.
So defense's argument or response to the court's stating that it was going to respond by referring them to exhibits 4 and 5 was that those 2 exhibits did not reveal the serial numbers of the pre-recorded buy money that was given to UC 72 versus UC 39.
So it didn't specifically state it wasn't circled saying these are the serial numbers that went to the 72 versus 39. However, by inference and with the testimony, they could say when...
The jury had to piece it together based on Exhibit 4, Exhibit 5, and the testimony that was provided.
Yes, so the people, when they were responding to Note 4, had asked the court to include that testimony that from both Miro and Undercover 72, which spelled that out, and the court felt that that would have been a bit too leading, and that's why he just gave them and directed them to the exhibits, and once again noting that they could refer back to the judge if they needed further clarification or had a more specific
How do you
question.
respond to your adversary's issues with the stop?
With the stop? So a point of clarification, the detective did not immediately note that the defendant was wearing a black jacket. However, during the search, he did say that he was wearing a black jacket. So that wasn't something he noted when he approached him, but he, during the search, did say that he had a black jacket. As far as evidence that they were all wearing the same clothes and all matched the description, that's not supported by the record. I think one could argue that that would have been more memorable if they had stopped and
If they all had red
wearing
sneakers?
matching outfits. Yes. So the fact that the detective couldn't remember the 2 people who were not the defendant and who were immediately released after the confirmatory identification, I think makes sense and is kind of illogical what his memory would have been honed in on. If there are no further questions, we ask that you affirm.
Thank you.
Thank you.
Just starting with the second issue quickly, the jury note issue. I just want to, it was a very, very specific question here. And, the judge has an obligation to, as Taylor said in the Court of Appeals, to get this right and to answer the question very specifically. And it didn't here. And the problem was, again, there are two reasons. First of all, the detective who circled this did not distribute the money to the 2 undercovers. He gave $120 to undercover 72, and it was undercover 72 who distributed it. So circling this doesn't answer the question. And second, we don't know when this happened. This is a case where the main issue in the case had to do with the pre-recorded buy money and whether it was commingled. And remember, this is a case that the jury was deadlocked 7-5 twice. They wrote 2 notes in favor of acquittal. So this was an absolutely critical moment of the case, and the judge just did not get this right. And just again on the stop, I just want to emphasize there were 3 people stopped. I just think we have to assume that they were probably all wearing red sneakers, and this was such a threadbare description. I just don't think it met reasonable suspicion. Thank you so much.
Thank you. Thank you both. Turner v. New York State Office of Court Administration. Yes, you may proceed.
Thank you, Your Honor. Good afternoon, and may it please the court. The respondent office, New York State Office of Court Administration, has disciplined the petitioner, Donnie Turner, for conduct which occurred off-duty and has absolutely no connection to his job function or job duties. There is no dispute that there is no direct...
Does it have to have a connection to his job function for it to come within the purview of OCA discipline?
Our position is that, yes, there must be a nexus between the employee's job duties and job functions and the off-duty conduct for which the employee is now being disciplined. And in this case, there is no nexus between his employment and the incident which occurred off-duty, not on work hours, not on OCA property, not involving any other OCA.
What about so we're talking about the rules, right? What about subsection 1 or Roman numeral 1? Court employees shall avoid impropriety and the appearance of impropriety in all their activities. Court employees shall respect and comply with the law. Court employees shall adhere to appropriate standards in performing the duties of their office.
Yes, Your Honor. To point out in subsection 1 of Rule 50.1, court employees shall respect and comply with the law. Mr. Turner was arrested for the incident which occurred. However, the charges against him associated with the arrest were later dismissed.
But the fact that they were dismissed, is that really germane to this issue in terms of the court rules, given the fact that he did admit to, I believe, to assaulting this individual?
He admitted to reaching into the car, moving past him and grabbing the keys from the car, and then returning to his car to wait for the police after he had called 911 several times.
Well, he also blocked the individual's right hand or hand with his petitioner's hand. So wasn't that tantamount? Wasn't he charged with an attempted assault on that?
He was charged with assault. However, as I said, the charges were dismissed. And frankly, Your Honor, to determine whether or not...
The rule doesn't require... you don't run afoul of the rule only with a conviction. Clearly, something more than a need for a conviction is something less than a conviction is contemplated because it speaks of respect and comply with the law.
Yes.
He admitted going into someone else's vehicle and removing their key from their car.
Yes, Your Honor. This is after the individual appeared intoxicated to Mr. Turner and attempted to flee the scene of the accident before the police arrived.
Turner's not an officer. He could have waited for the police. He could have taken his license plate and said he left the scene.
Certainly, perhaps it wasn't the best thing to do. However, it was an emotional experience for him. And I would note that respecting and complying with the law, that's for a court of competent jurisdiction to determine whether or not the law was complied with. There was no conviction, there was no guilty plea, and after the...
Well, that's what my colleague just stated. Do the rules require that there be some type of conviction?
If you look at case law for similar cases as this, you'll see that the vast majority of them, if they don't include moral turpitude, or excuse me, if the off-duty conduct does not include moral turpitude, almost always they include a conviction based on...
So the hearing officer concluded that the petitioner's behavior was aggressive, reckless, dangerous, also that it could have escalated to injury, and also noted that petitioner accepts no responsibility and shows no remorse for his unlawful action.
Again, Your Honor, respectfully to the hearing officer, it was not him to determine whether or not Mr. Turner broke the law. I would also point out...
He didn't say that. He said the hearing officer stated his behavior was aggressive, reckless, and dangerous, could have escalated to injury, accepts no responsibility, shows no remorse. He doesn't talk about... he states there's a serious disregard for the law, but he did not conclude that there was a violation of the law.
Yes, Your Honor. I would also note that there's no evidence in the record which would show that Mr. Turner was aggressive.
That's not aggressive behavior by, putting your hand into someone else's vehicle, grabbing the keys, taking the keys, snatching the keys from that person's the ignition, and then blocking that person's hand when they're trying to stop you from doing so. That's not aggressive behavior.
Mr. Turner described it in in not such aggressive manner.
I'm sure he just walked over and said, "Excuse me, may I have the keys?" And just walked over and took the keys out of the ignition, right? I'm surprised it was that there's still keys in ignitions. My car doesn't have it.
You also have to keep in mind the tough burden that you face. This is an Article 78 proceeding. It's not what the five of us might think is the appropriate punishment. It's whether we should upset what, in effect, the administrative agency, if you will, has determined.
You
Yes,
can
Your Honor.
respond to that on rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. Robin Rothman for Respondents, New York State Office of Court Administration, Chief Administrative Judge Zayas, and Chief Judge Wilsons in their professional capacities. May it
So
please.
why should the rules apply to this conduct that didn't happen at work?
Well, quite frankly, the Court of Appeals has resolved this issue in favor of you can be disciplined for off-duty conduct so long as it violates a rule of the employer regarding such conduct. And that case is the Haug versus SUNY Potsdam case. In this case, petitioner is a court office assistant working for New York County Criminal Court.
For over 18 years.
For over 18 years. He understands the rules. He obviously works in a criminal court capacity, so he should understand.
He was a clerical employee. So does that make a difference that he's a clerical employee and not law enforcement? He's not a court officer. He's a clerical?
Well, Justice Weber, I think it does make a difference, but the totality of the circumstances, he's a court employee. He's public-facing. He works with the public. The judiciary.
What does a court officer assistant do?
It's mainly clerical work. My understanding is that assisting with chief clerk duties, assisting with other clerk duties, filing of paperwork, assisting the public and answering questions of that nature. But I think regardless here is that we, as the judiciary, we have to uphold an impartial workforce. We have to make sure our workforce understands and respects the public. And here, regardless of whether that was done at work or outside of work, we have to make sure that the public knows that it can rely on our judicial employees.
But not every off-duty conduct becomes a basis for discipline. So how is this line drawn at which the employee is subject to discipline? Where do we draw this line?
Well, the line is drawn with, of course, it's a case-by-case basis. So Justice Friedman, I understand that not every off-duty conduct would be subject to discipline, but it's really on a case-by-case basis. Obviously here, the petitioner was arrested. He was involved in aggressive behavior. It was involved touching of somebody without that person's permission. It was involved in confiscating of property without that person's permission. So regardless of whether or not—
But the counter-argument to that is that he was trying to stop someone who just rear-ended him, appeared drunk, and was trying to leave.
So the record reflects, in his testimony himself, he tried to say he was intoxicated, and then he walked it back a couple times. He said, well, I'm not a doctor, I don't know. So it seems to be that might just be an attempt to excuse the behavior, and there was no evidence or independent evidence besides his, what he viewed to say that this person was
Had there been independent evidence, would then his conduct have been okay?
It wouldn't have been okay. It wouldn't have been okay at all.
And had the charges not been dismissed? I mean, the charges were dismissed, so is there any relevance to that?
There is no relevance because, again, it involved an intentional touching of somebody without that person's permission. And it involved intentional taking of property without that person's permission. Either way, it's conduct that is unlawful. But even still, in a criminal court context, there's a higher burden in establishing criminal behavior, whereas in an administrative proceeding, you're talking about a substantial evidence standard. It's a significantly relaxed burden. There must be some evidence to show that the person engaged in that conduct. And here, the evidence was sufficient. There was police records and the petitioner's own
I don't
testimony.
think he denies it.
No, he didn't.
He doesn't deny it.
He doesn't deny it. Doesn't deny it. So with that, I rest on my brief.
Thank you.
Thank you.
Thank you, Your Honor. As counsel for the court, the court's just stated, it's on a case-by-case basis in which determining off-duty conduct would be subject to discipline. In this case, we would submit that because there is no nexus between his job duties and the conduct for which he is disciplined, that the relief in the petition should be granted in its entirety. There is the only reason the court system knew of this arrest, or would have any reason to know, is that there's an automatic reporting feature wherein employees who are arrested are reported to the courts. Before the hearing, the only people who knew of the arrest were Mr. Turner, those involved, the arresting
So
officer.
that would have made it all right if if the court system never learned of the arrest?
No, Your Honor, my point here is that it was not a notorious incident. It brought no disrepute on the court system.
So there was a Fourth Department case I think I saw where the employee was reprimanded because he was at a Hell's
Hells Angels, Your Honor.
Angels
Yes.
demonstration or something of that nature, and he was reprimanded for that and disciplined for that. So you're saying that there's a difference between that type of case and here where we have an actual taking of property and an actual assault?
Certainly. In the case you're referencing, apologies, I can't remember the name off the top of my head, but the employee involved was a corrections officer. So they are held at a higher standard. Another case referenced in my brief discusses that. However, corrections officers, police, special officers, peace officers are held to a higher standard. And in that case, the known association, well-documented association with criminal elements of the Hells Angels.
That was matter of Thompson v. Jefferson County Sheriff.
Yes, Your Honor.
Thank you. Thank you both.
Thank you.
People v. Michael Webb. Yes, you may proceed.
Good afternoon. Simon Greenberg on behalf of Michael Webb. I'd like to start with the grand jury issue, please. Detective Sean Casey's hearsay testimony and
What evidence is there in this record that that testimony was hearsay?
the evidence, Your Honor, is that Detective Casey testified that during the course of his investigation, he spoke to witnesses and he learned that the person referred to as Shania's boyfriend was Michael Webb.
It requires an inference, right, that it's hearsay. He doesn't specifically say that the information was provided by a witness, and the prosecutor does not follow up in the grand jury presentation. Is that right?
The prosecutor does not, after Detective Casey testifies that, as to what he learned, the prosecutor does not ask a further question. And yes, I think that
And just to make sure,
it's a very clear inference, Your
This is
Honor.
not the case where, well, I'll let you make the argument. Is this the case where the prosecutor, there's evidence to say that the prosecutor knew at the time that he asked the detective that question that the answer would be hearsay and asked it nonetheless?
There must be, Your Honor, because the
Based on what?
prosecutor had certainly spoken to the police, to the detective, and was aware of the source of the information that the detective was testifying.
How do we know that?
Because, I mean, that is not in the testimony itself, Your Honor, but...
So where is it? So how do we know that that's the case?
Well, we know it's the case because prosecutors, when they prep their witnesses to testify, and a witness is saying that they learned certain information, I think it's a very fair inference that the witness has told the prosecutor what the source of the information is.
As a former prosecutor, I don't know, and also knowing some prosecutors and also seeing grand jury presentations, I don't know whether you can make that assumption, but even more so, it's not in the record. So we don't know that. The argument is that it was hearsay, but we don't know that it was in fact hearsay. There's also an argument to be made that it was not hearsay, that it was not based upon hearsay.
That's incorrect, Your Honor, respectfully, because the only way that this could have been non-hearsay is if the source of the information was a statement that qualified under a hearsay exception. And the only such exception that is that
No, the issue as to whether or how he learned of the defendant's identity, the basis for the learning of the identity could have been non-hearsay.
well, it could not, Your Honor, because he learned it by speaking to witnesses, and that witness was certainly not Mr. Webb. And if the source of the information was any statement made by someone who was not in court, that is hearsay, and it's clearly being introduced for the purpose of.
So we know, again, we know, how do we know that it was based upon a statement? How do we know that it was not based upon some identification, some investigation, i.e. the relationship between the defendant and the girlfriend?
Because we know that it was based on statements from out of court witnesses, because he said that he learned this information by speaking to witnesses. So the information is coming from words spoken by witnesses. And what's crucial here is that this hearsay had a decisive impact on the key factual issue in the case, which is whether Mr. Webb was the person that Joseph McGivney referred to as Shania's boyfriend. And there was
He
no.
was Shania's boyfriend, is that correct?
That was not established in the grand jury
No, it
testimony.
wasn't. So,
Your
but that's
Honor.
the other issue. Is this not all foreclosed by the fact that there was a jury verdict finding the defendant guilty?
It is not foreclosed, Your Honor, because this is an argument that the integrity of the grand jury proceeding was impaired. And that is, case law is very clear, as is the clear language of CPL 210.30, that only an argument that the evidence was legally insufficient is precluded, but an argument that the integrity of the proceeding was impaired is not precluded. And here, immediately after Detective Casey spoke this critical hearsay, the prosecutor said to the jury, the grand jury, I would like you to vote on charges against Shania's boyfriend, who is also known as Michael Webb. And so there's no evidence to make this connection between the person in Joseph McGivney's testimony referred to as Michael Webb, as Shania's boyfriend, and Michael Webb. But the prosecutor then repeats it as a matter of fact on this critical factual issue, and as though it's something the grand jury doesn't even need to decide for itself. The prosecutor is just telling the jury that Mr. Webb is the person referred to as as Shania's boyfriend, and that irreparably impaired the integrity of the proceeding, and it was a miscarriage of justice, and the only proper remedy is to dismiss the indictment, Your Honor.
Thank you.
Good afternoon, Emily Aldridge for the People.
Counsel,
People,
how
can you,
was-
I'm sorry. People, can you respond to your adversary's argument, considering that the transcripts show on page 91 that the people address how Detective Casey was anticipated to testify, that he obtained from a confidential informant the description of Shania's boyfriend, who used the nickname Murder?
Yeah, that does come in after the fact, so now we are in a Oakley-type situation. In the grand jury itself, it was pursuant to an investigation. Did you?
Well, was that the question? Was it pursuant? Because I thought that the detective testified that pursuant to an investigation, he learned that it was the defendant. But your friend states that that the question or the statement was it was pursuant to statements made by individuals, his conversations with individuals.
Well, the prosecutor asked pursuant to your investigation, did you conduct an investigation? Did you talk to people? Just very basic questions.
And so was the response yes, based upon my conversations with various individuals?
He simply said yes. And
Wasn't the question, did there also come a time during the course of this investigation that you learned the identity of the individual referred to as Shana's boyfriend or Shana's man? Answer, yes. What's the identity of the individual referred to as Shana's boyfriend or Shana's man? Answer, Michael Webb.
Precisely.
So it's pursuant to the investigation, so we don't know what that investigation entailed.
Exactly.
In terms of conversations with individuals, which would arguably be hearsay, or whether it was the investigation took on other forms.
And yes, Your Honor, the basis of that knowledge was not examined because defendant did not timely raise this issue. And therefore, there's no development of this record, and as my adversary admits, this issue is unpreserved.
So I just want to be clear, because counsel said something that I didn't appreciate from the record, and I'm not sure that it's accurate. He made the representation that the connection between Shayna's boyfriend and Michael Webb was made by the prosecutor. But based on what my colleague just read, it was made by the officer.
At some point, after the grand jury testimony, when there was discussion before the trial regarding the parameters for the testimony.
I'll ask it this way. What in the grand jury connected the term Shayna's boyfriend to Michael Webb?
That single question, the one solitary question from the prosecutor, and did you determine the identity?
So was there a concluding statement by the prosecutor in asking for the indictment? I asked that you vote charges of whatever as to the defendant, David Webb, Michael Webb, also known as Shayna's boyfriend?
Yes, precisely.
But that was after the officer had testified?
Precisely, yes. And there were no questions.
And do you have a non-hearsay possibility for how he would have known that information?
There's some possibilities. As Mr. McGivney testified, he was always wearing the same outfit, so we don't know how, again, this record wasn't developed, but saw him about Detective Rodriguez, who testified, had significant contact with Shawnee and may have known more, but he was always wearing the same outfit. He might have known him from the neighborhood.
This is the independent source hearing? This
No,
was
no,
testimony,
no,
but this was testimony of the independent source?
No, this is, you're just asking whether there might be any other reasons why non-hearsay ways he may have known. He might have known, Detective Casey may have known him from the neighborhood.
I see.
He might have overheard defendant at some point. And again,
This record, we just don't know, right? But would you agree that if the record bore out that the prosecutor knew when asking that question that the answer was based on hearsay, that would be a major problem for you?
Well, here, the prosecutor, there's no indication that the prosecutor did know. In
Granted,
fact,
but that's not my question. My question, I'm changing the fact pattern on you, right? The fact pattern is the prosecutor knew. You would agree that that's a problem.
that would be a problem. The question then would be whether this rises to the very high standard that is required to dismiss an indictment, especially after trial. Here's a case where this case went to trial. A jury found him guilty and did so based on testimony that had nothing to do with Casey. Casey did not testify. Instead, McGivney, who had had several interactions with defendant prior to this, did the point out. He explained.
I had that question as well in terms of Casey, because I could not understand the defendant stating that he did not receive he did not know the testimony of Casey. So Casey did not testify at trial, so therefore Casey's grand jury testimony was not turned over prior to trial?
The specifics of that, I'm not sure. I believe the argument is that it was turned over.
I thought it was that he did not see the testimony until right before trial, so he didn't know what had occurred during the grand jury presentation.
There was, and I'm not entirely sure, my understanding in the first trial was that there was some sort of family issue for why he didn't testify. The prosecutor did indicate that he would likely be testifying in the second trial. I don't know why he didn't testify, but
Thank you.
Thank you.
Thank you. I think that to clarify, I think something that's a little confused here, the prosecutor in asking the question does not need to know that the answer is going to be hearsay in order for the integrity of the grand jury proceeding to be impaired. What needs to happen for the integrity to be impaired is that hearsay is presented and that there is no other admissible.
Has to know that hearsay is presented, right?
That is incorrect, Your Honor. I think that there are
So
some.
you're saying that a prosecutor has a duty to basically cross-examine any statement that's made in the grand jury that could possibly implicate any rule of evidence?
Well, but here, I think that whether the prosecutor knew that the evidence was hearsay or not is I think, at least part requires the prosecutor. It's just not relevant, Your Honor, because the question is, was the evidence hearsay? It's not whether the prosecutor knew that the evidence was hearsay. And here the evidence was hearsay because—
We don't know.
How do we know that?
We know that because Detective Casey said that he learned this by speaking to witnesses.
No, but that was my question, and apparently that's not what it was. It was based upon his investigation. Investigation is different from statements. That's why when you stated before that his statement was that I learned this from speaking to various witnesses. That drew a question in my mind because I did not think that that was what the testimony was. It's investigation.
The testimony was, did you continue investigating? Yes. Did you speak to witnesses? Yes. During the course of your investigation?
During the course of your investigation.
And that during the course of investigation, I think it's a very clear inference from the series of the 3 questions in a row that the source of the information learned during the investigation is the conversations with the witnesses.
One of the fair inferences to make from that is that an investigation doesn't include speaking to witnesses. That doesn't mean that that particular information came from witnesses.
I think respectfully that the testimony is clear, Your Honor, and for the prosecutor to then immediately after this critical hearsay is presented, say to the grand jury, Mr. Webb is known as Shania's boyfriend, is stating the...
That's not what was stated.
That is what was stated, Your Honor.
That was when the prosecutor is asking the grand jury to vote as to certain charges.
Yes.
And that is what is done in the grand jury. I ask that you vote charges X, Y, and Z as to the defendant. That's what happens in the grand jury. That's what is stated.
You don't repeat the key critical issue as though it's a matter of established fact, and then give the grand jury encourage the grand jury to rely on
So the prosecutor should not have stated, I ask that you vote charges for manslaughter or murder in the 2nd degree or what have you as to Michael Webb?
The prosecutor should have said, the prosecutor could have said that, Your Honor. What the prosecutor should not have said
because he or she stated the boyfriend of Shania or Shania or whatever, therefore that makes it, that goes to the issue as to hearsay?
It is, Your Honor, and it's a critical error because the prosecutor is repeating hearsay and stating it as a matter of...
The hearsay is that he was the boyfriend of Shania?
That is, the hearsay is Detective Casey saying, I learned during my investigation by speaking to witnesses that he was, that Michael Webb was the person referred to as Shania's boyfriend, and that is exactly what the prosecutor repeats probably less than 5 seconds later, because it's 2 or 3 lines later in the transcript. That's clear hearsay, and the prosecutor is encouraging the grand jury to rely on it, and that's fundamentally unfair and requires the indictment to be dismissed, Your Honor. Thank you.
Harmon Becker Auto versus Avnet. Yes.
Good afternoon, Your Honors. Daniel D'Alessandro on behalf of appellants Harmon Becker Automotive Systems, Inc., Harmon Becker Automotive Systems, KFT, and Harmon Electronic Systems, Ltd. I'm here with my co-counsel, Charles R. Quigg of the Bar of the State of Michigan, and request that he be permitted to participate and argue the appeal.
Yes, excuse me, that's granted. Go ahead, proceed.
Thank you, Your Honors.
Good afternoon, Your Honors. I'm Charlie Quigg here on behalf of Harmon. This appeal is from the Supreme Court's order dismissing Harmon's First Amendment complaint under CPLR 3211A7. That context is critical for purposes of this appeal. I have 2 points. First, Hornbook law says that ambiguous contracts can't be construed as a matter of law, precluding dismissal at this stage of a case. Here, the parties' memorandum of understanding found at page 309 of the record.
Which specific provision of the memorandum of understanding do you say that Avnet breached?
Your Honor, if you have it in front of you, page
Yes, I do.
309.
Page 49 of the record.
It appears at several different points.
Right.
Yeah. So if you look about 2/3 of the way down the page,
Right.
Second sentence of the first paragraph, the customer, that is Harmon, shall provide the vendor, that is Avnet, with either purchase orders or a rolling forecast of its requirements for the list of products, which the vendor, Avnet, will use for purchase order placement towards the supplier, and critically, for shipment allocation and delivery call-offs to customer. So, in other words, the language is at least susceptible to being read that Harmon must order its requirements for Broadcom chips from Avnet, and that Avnet will use those requirements to determine what to ship and deliver. In other words, Avnet must ship and deliver according to Harmon's requirements.
Doesn't Harmon admit that it ordered chips from sources other than Avnet?
Yes and no, Your Honor. Harmon does.
Either yes or no. It can't be both.
Well, fair enough, Your Honor. The answer is yes, but only.
Doesn't that take it right out of it being a requirements contract?
No, Your Honor, it doesn't. The only circumstances in which Harmon has ordered from other suppliers is to mitigate damages after Avnet breached. And that can't be held against Harmon, obviously. That's its duty under the law.
Where in the contract is there a requirement that Avnet produce these chips, deliver the chips?
Yeah, where's the language that imposes that obligation on Avnet?
I'd refer Your Honors back to the language that I was just discussing with Justice Friedman.
Yes, but that language doesn't have an obligation on Avnet to do anything.
Your Honor, I disagree. The sentence, and I'm going to
I
omit
wouldn't
some
say
words.
to do anything, but to do what you say it means. It doesn't have that sort of an affirmative obligation.
Respectfully, Your Honor, the sentence says the vendor, i.e. Avnet, will utilize Harmon's requirements for shipment allocation and delivery call-offs to the customer, i.e. Harmon. Will is mandatory. That's the language of an obligation.
Doesn't that referring to their forecasts and invoices or purchase orders?
Yes.
They will use that in order to determine what they're going to order, as opposed to they have an affirmative obligation to order chips and deliver them?
To supply the full quantity of chips Harmon wanted?
Right.
I don't see the obligation.
Well, Your Honors, I think what you're getting at is potentially the ambiguity here. That sentence, at least in our view, is susceptible to being read as Harmon will place purchase orders or provide forecasts for its requirements, which Avnet must then utilize for purposes of making deliveries to Avnet.
From your perspective, there is a villain in this situation. But isn't the villain Broadcom? I mean, Avnet is not manufacturing the chips. What do you want from Avnet? It's Broadcom who did something wrong from your perspective. What was Avnet supposed to do?
Well, sir,
I mean, if Broadcom is not giving Avnet the chips, how can Avnet give Harmon the chips?
I understand the question, Your Honor, but I would point the court to the allegations in our complaint that Avnet and Broadcom, although discrete entities, work closely together. Broadcom directed us to work with Avnet. Our complaint alleges that Broadcom chips are not generally available.
But they
in the
are discrete
marketplace.
entities.
Yes, Your Honor.
And you withdrew your appeal as to Broadcom?
Yes, Your Honor.
Okay.
Moving on.
Where else in this MOU is there an obligation on Avnet to supply as many chips as Harmon wants? What language in here supports that?
Again, Your Honor, the MOU refers to Harmon's requirements, and it refers to Avnet using those requirements for shipment allocation and delivery call-offs to Harmon.
If you meant to say, whatever we require, you have to supply, there's a way to say that in plain English.
These are
And it's-
sophisticated parties.
I was going to say, again, we're dealing with sophisticated parties. You have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Benita Robinson for the Avnet appellees. I want to address briefly the requirements contract point, but then also address the second alternative breach theory. On the requirements contract point, Harmon does not dispute that a requirements contract has several essential features, one of which is an obligation on the seller to furnish all of the buyer's requirements. as Your Honor's question
But
suggested.
there's also a breach of contract cause of action here, which was dismissed also, right?
So there was a breach of the breach of contract cause of action is still in the case. It was the declaratory breach action that was all the claims were dismissed, but the declaratory breach claim is not on appeal.
I mean, there's no breach of, as things stand, there's no breach of contract cause of action left either, right? Why in terms, as a matter of pleading, isn't there enough here to say that there is a breach of contract cause of action? You've got these terms and conditions, you've got these purchase orders, which some of them cross-reference. I know it's your position that many of them post-date the purchase orders. But why, when you put all of that together, isn't there enough to say, well, you know, Harmon has stated a cause of action for breach of contract?
So Harmon's only allegations as to breach are that Avnet failed to timely deliver the chips. That's it. That's the only allegation. It's repeated in one other place in the complaint, so it appears in 2 paragraphs, but that's the entirety. But it's quite clear under New York law that to actually plead a breach cause of action, you need to identify what the contract is that is being breached. And Harmon identifies 15 different documents that it all calls the supply agreements. They cover a 6-year period.
They don't succeed in pointing to a specific provision that's breached.
Well, so they don't even point to the document that's breached. They don't point to which contract they're talking about. Is it the one from 2017? Is it the one from 2023? We don't know. But then again, they also don't point to a specific provision that's breached. And one of the things that's very telling is that Harmon concedes that the information about when chips are due and how many chips are due, the information about quantity and about timeliness that Harmon says that is at issue is contained in something called releases. They have not attached any releases to their complaint. They have not described the content of any releases. So there's literally nothing in the complaint that suggests when Avnet was supposed to deliver chips and when it failed to do so. So that, I think, that dispenses with the alternative breach theory. It also dispenses with the requirements theory, because even if you were to read the MOU as a requirements contract, and you should not read it that way because it's missing the essential features of the contract, there's no allegation or no sufficiently pleaded allegation about when the requirements were not delivered. So that can really settle the whole case. I do want to point out, you know, as I mentioned at the outset, Your Honor's questions focused on the absence of any obligation for Avnet under the MOU to supply all of Harmon's requirements. And I think that's absolutely correct. That obligation is not there and cannot reasonably be read there. There's also an absence of any obligation for Harmon to purchase all of its requirements from Avnet. And I want to go back to the language on 309 of the MOU that Harmon's counsel focused on because it was misstated slightly. What that language says, it gives Harmon the option of either placing purchase orders to Avnet or a rolling forecast of its requirements. The purchase orders, there is no reference to the requirements. It is purchase orders without reference to what Harmon's requirements are. So just from that plain language, there's no basis to conclude that one of those features of a requirements contract, that Harmon purchase all of its requirements from Avnet, is present. It's just not there. And if Your Honors have no further questions, I'll rest on the briefs.
Thank you.
Thank you, Your Honors. I'd like to start with the second theory and the purported insufficiency of our allegations regarding how Avnet breached, even assuming the MOU isn't a requirements contract, getting to your questions, Justice Friedman. As the court knows, a complaint must only give notice of the subject matter of a claim, not plead all the details underlying the claim. And here, Harmon's complaint makes very clear that the gravamen of its claim is that Avnet failed to deliver chips as and when required by Harmon. Harmon identified the part numbers that Avnet failed to deliver. It identified the purchase orders and scheduling agreements under which Avnet failed to deliver. It explained that under those agreements, Harmon would communicate specific quantities and delivery dates to Avnet via releases sent through the party's electronic data interchange or EDI system. To be sure, Harmon didn't include allegations regarding every single release for several reasons. Among other things, it would have added dozens or hundreds of allegations to the complaint, and Avnet's breaches were ongoing at the time Harmon filed the amended complaint. But as Avnet's own affidavit, the affidavit of David Paulson that it filed in the Supreme Court shows, this is at pages 177 and 178 of the record, Avnet has more than enough information to respond regarding its performance under the agreements attached to the complaint. And even if Avnet's feigned confusion were credible, any uncertainty about what this is really about can be resolved with a discovery request or two on remand. I also just want to touch briefly on the point that these are sophisticated parties. I certainly understand the basis for that comment more generally, but I would just respectfully suggest that even a cursory review of the MOU suggests that the parties that drafted this MOU were business people, not lawyers, not particularly sophisticated. And I believe that that is self-evident from the face of the document. Unless the court has any other questions, we'd ask that the court. Thank you, Your Honor.
Thank you both. Siguencia v. City of New York.
Good afternoon. My name is Jennifer Friedman on behalf of the city, the DOE, and the SCA. And, we're here today to talk about a summary judgment motion decision of the lower court. The judge distinguished between the plaintiff's testimony and what was called the amended testimony that was based on information contained in correction sheets to his deposition testimony of two different depositions. It's our contention that the court should not have relied upon the amended.
Because he didn't submit an explanation as to the changes.
Well, also, it was in English, and there was no translator affidavit. The plaintiff had testified at his 58 hearing in two depositions that were included with the aid of a Spanish interpreter.
And the affidavit wasn't submitted.
No, there was
as
no.
mandated by CPLR 2101, correct?
That is correct.
How did you, or what did you present to show that that the plaintiff was the sole proximate cause of the injury, for his injuries?
We based it upon the plaintiff's testimony, which was that these particular scaffold stairs that he had walked up, he had testified he had walked up them on prior occasions.
There certainly is a point of view here that the way to carry those aluminum planks was not to use the staircase on the scaffold. Was not to use the scaffold staircase. Doesn't the plaintiff testify at the 50H hearing that his foreperson told him to carry the planks up the staircase? And doesn't that create an issue of fact here which supports Supreme Court's denial of your motion for summary judgment on the 241 claim?
I respectfully disagree. On page 331 of the record at the 50H, the plaintiff was asked, did Foreman Mohammed show you how to carry the planks from the ground up to the roof, in which he said no. The same question was asked of the bricklayer, in which he said no. And it was also on page 462 of the 50H hearing. Did the bricklayer tell you how you were to take the planks from the ground up to the fourth level of the scaffold, at which he said no again? And then when you look at his deposition testimony.
On page 347, doesn't the plaintiff testify that the foreman told him to take it up the staircase? That doesn't appear at page 347?
I don't have 347 in front of me, Your Honor, but I was looking at page 331 and 462.
I know there are different things said at different times. This is the 50H hearing. It's probably too early to say it's a feigned issue of fact, but I believe at 347, the transcript does show that the plaintiff says that the foreman told him to take it up the staircase, and if you have that evidence in the case, isn't that enough to support denying your motion for summary judgment?
And also, he states on 346 that he was told that they didn't use a pulley, but rather he was instructed again to take it up the stairs because we don't have the pulley.
On page 346, Your Honor?
I'm sorry, 346 and 347 and 350.
Yes.
350, he talks about the fact that he didn't see a pulley, but 346 and 347, as my colleague states, is where he testified that the foreman told him, we don't have a pulley, to take it up the stairs.
Yes, and also on page 347, the question was, did you ask Mohammed to use the pulley? And he says no. And he says, why didn't you ask him? He said, I was afraid I would be sent home. And then the question was, did Mohammed ever tell anyone to go home if they asked a question, in which he said no. And I disagree.
Where is the evidence that someone told the plaintiff, instructed the plaintiff to use the hoist or the pulleys? Can you direct me to anywhere on the record where that evidence exists?
I don't believe he was that particular point, but he did testify that that particular staircase was for people to go up and down. It's not to carry any type of material, because for us to carry the material, we use a pulley.
Right, but the issue is there not a conflict? Because he states that he was told to use the staircase, and that he was told that there's no pulley available. But you did not present anyone to contradict that and state that he was never told to use the staircase, and he was told to use the pulley or a hoist.
Well, he himself testified he knew not to use the staircase to carry materials.
Counsel, but isn't it an issue of fact that requires denial of your summary judgment? He said he was told. There's nothing in the record that says that anyone instructed him to use the hoist or the pulley. Isn't that an issue of fact?
No, when I look at the court's decision, the court states that plaintiff originally testified that he was never given specific instructions as to the manner in which to transport the planks onto the scaffold. Plaintiff amends his testimony to allege a bricklayer told him to carry it up the stairs and not use the pulley.
So someone told him to carry it up the stairs?
Based on his amended testimony in the court's order.
Yes.
Yes, that's how I look at it.
Well, I'm looking at the court's decision as well. And it states that the plaintiff acknowledges that there was different versions. However, essential, as plaintiff was carrying the first plank up the stairwell, he fell. And that there was no testimony, nothing by movement to establish that he was not told not to use the stairs.
Well, Your Honor, we had, plaintiff had been questioned about this particular bricklayer. All we got from him was a man with a beard from India. He didn't know who his employer was. There was no particular way for us to identify this man to obtain rebuttal testimony. And that goes to the hearsay issue that plaintiff has made, because there's no way.
It says that issues of fact remain to be resolved at trial, not limited to exactly how the accident happened and whether or not plaintiff was directed to carry the plank up the stairs instead of using the hoist, or whether he decided to do it on his own. Isn't that an issue of fact, counsel?
No, when I read the court's decision, it states that originally plaintiff testified he was never given those specific instructions, and it was in that amended testimony that he changed his position. And it's our position that that amended testimony was improper because it was not appropriate pursuant to the CPLR, it was in English when it should have been in Spanish, and there was no translator affidavit, and the court should not have accepted it.
Thank you.
Thank you.
Good afternoon, Your Honors. My name is Stephen Weinstein, and I'm here on behalf of the respondent, Franklin Siguencia.
Counsel, what if we agree with her that the amended, the signed transcript should not have been accepted by the court? What happens to your case?
There's still evidence that there was a question of fact, because the testimony in the 50H, exactly as you were asking, shows that he had stated with inadmissible form that the foreman had told him to bring it up the scaffold stairs. So plaintiff submitted 2 forms of opposition with respect in demonstrating a question of fact, one of which was the 50H testimony, and the other one was the EBT correction sheets. If the EBT correction sheets are deemed null and void because they didn't have the requisite affidavit as required, there's still a question of fact because there's still something in the record which shows that he didn't do it on his own. The thrust of the defendant's motion was that he was the sole proximate cause because he decided to go up the stairs on his own. But that's not the evidence in the case. The evidence in the case shows that he was told by his foreman to do it. He repeatedly said that throughout. Even in his last deposition, when he said there was a hoist, it was around on the other side of the building, and he was asked, well, why didn't you use the hoist? He said, because I was under orders. He's a laborer at a construction site. He gets direction from his foreman as to what to do and how to do it. He doesn't make decisions in that regard. So here the evidence was submitted that there was a clear question of fact because the 50H testimony established that the foreman had told him to do it. And there was nothing that was submitted in opposition to that statement. So therefore, it was entirely appropriate for the lower court to deny the motion.
There's nothing on the record that he was instructed to use the staircase, correct?
There is something on the record, his own testimony, his 50H, where he said, Muhammad, the foreman, told me to bring it up the staircase.
But there's nothing showing that anyone instructed him not to use the staircase.
No.
To use the pulley.
That's right.
Is there anything in the record that anyone instructed him to use the hoist?
I'm sorry, I didn't listen.
Is there anything in the record that anyone instructed him to use the hoist rather than the stairs?
No. In fact, there's no evidence whatsoever. All there is was an affidavit that was submitted by a project manager for the SCA who looked at the site safety plan. He says, look, there's a hoist there. And then they submitted an affidavit from the employer who said there were 4 hoists generally on site. But there's no evidence at all whatsoever that he was instructed to use it. In fact, the evidence is to the contrary, that the foreman told him to take the scaffold stairs. There were clear questions of fact in this case. It was entirely appropriate to deny the motion for summary judgment. It's entirely appropriate for this case to go to trial.
Thank you.
Thank you.
If you have any questions on rebuttal, otherwise I'll rest on my papers.
No, thank you very much. Thank you both. Griffin versus Abid.
Good afternoon. May it please the court, William O'Connell, Goldberg Sigala for the defendant, appellant, Westside Radiology, PC. Your Honors, this case is about service on a corporation. It has to be a little different. There's specific authorized persons, and in this case, it wasn't on an authorized person. The process server did have an affidavit of service, and that normally is prima facie evidence of proper service. But in this case, my client submitted an affidavit that rebutted it with specific facts. And that's what happened. The affidavit of service said authorized to accept, just generally nothing further about any conversation.
So this is the affidavit from Donovan O'Spammer?
Well, the affidavit of service of the process server, I'm sorry, I should be more clear, Your Honor, of Zanaki Poe said authorized to accept. But my client submitted an affidavit, and in it, importantly, shows that he had personal knowledge of this corporation's practices in terms of staffing, location.
That's Spammer, Mr. Spammer.
That's Spammer, yes.
Right. Spammer says that, right, his responsibilities including monitoring legal pleadings, conducting a search, and found no record that they had received the service.
Yes. So he's putting in an affidavit challenging the process server's statement, authorized to accept. That's a direct.
Saying there was no one at that location that was authorized to accept.
There was no one. I guess he could have submitted an affidavit and went down 1 to 50 of all the employees and said none of them are entitled to accept. In this case, he said no one at that office is entitled to accept service or process. So that really rebuts what the plaintiff's
If you were
process.
to accept your outlook on this aspect of what's in front of us, what happens to the case? There's, what happens with plaintiff's cross motion to be given added time to serve?
Yeah, respectfully, Your Honor, I think that motion, while it is a viable motion, should be denied in this case. There have been substantial delays in this case. I think due diligence has not been shown, so the plaintiff has delayed in terms of filing motions throughout, amending the complaint. It went on for about a
Shouldn't the
year.
motion court decide that motion?
Pardon me?
Shouldn't the motion court decide the motion?
They didn't, it wasn't decided on the merits, right?
No.
It was not decided on the merits.
She denied it as moot.
Yes, she did.
So should we not, so should Supreme Court not decide the motion on the merits?
I'm a big fan of judicial economy, Your Honor. and I'd
Well,
take care of it.
so are we, so are we, but you know.
It's my position, fair question, and obviously, and it's that in this case, there have been numerous delays. They're in my brief, so you don't have to listen to me right now, but the appeal back in the amending complaint stage, and therefore, I think we should just dismiss this case for the reasons stated.
I know you wanted to say.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. Aaron Halpern from the law firm Silver and Kelmacher on behalf of the respondent plaintiff in the case. The lower court hit the nail on the hub.
So there has been a lot of delay in the case, and why doesn't that delay justify denying the cross motion?
Your Honor, I'm glad you mentioned that. The delay, there has been delay, and I assert that the delay on the case is not the part of the plaintiff or the respondent here in the case. Unfortunately, the case was first commenced while this was a medical malpractice case initially served directly by the deceased who was alive at the time. It was filed timely. There's no contention on that. She passed away, and there was a surrogate's proceeding. She was appointed 9 months thereafter. The plaintiff immediately sought to try to amend the complaint as of right. Ultimately, it led to a notice of motion because there was some issue as far as whether or not it could be amended as of right, so a motion was made. We served everyone. By that time, defendant had retained counsel here, who's been counsel, and this is going back to 2021. And all there was back and forth as far as resolution and decision in the lower court regarding that decision for 9 months. That delay had nothing to do with the plaintiff. And there was correspondence, and in fact, counsel represented to the court and counsel, of course, that they were counsel for this defendant Westside Radiology, and that they did not submit any opposition. There was no contention. There was no opposition submitted. There was no dispute as far as the lack of opposition to the underlying motion. There was then a stipulated order, and it was an order. It was so ordered by the court. And not only was it so ordered by the court, but then there was a decision and order rendered by the court incorporating the so ordered stipulation. Counsel ignores that fact. They never moved for any type of relief with regard to the decision and order.
Westside never participated in that. They never signed on to the stipulation.
They never signed. That is correct, Your Honor. They never
They
signed.
had a right not to.
They had the right not to. They chose not to, but they also were participants leading to the motion. They were on notice, and they never opposed the motion itself. So, yes, they never signed the stipulation, but the stipulation then became an order, which was then incorporated into decision order and became law of the case. And it wasn't just on the issue of service. It was on the issue of amending the pleading itself. That order was amended the complaint to assert the wrongful death.
If the party says that they were never served, that it was never served, why would they bother coming in?
Your Honor, and I want to address that issue as far as the service. The only affidavit, the only evidence, if you will, which we obviously dispute, was an affidavit from Spamer. Spamer had absolutely no affiliation, no responsibility, no title, no job, absolutely no connection to Westside Radiology. They are his title and the affidavit. It's sparse, but it specifically limits his connection, his knowledge, and his personal knowledge at that to that of a non-party to the case who apparently acquired certain unspecified assets of Westside Radiology. The affidavit asserts to no knowledge with respect to personnel. There's nothing, it's completely silent as far as the affidavit of service, the description of the individual who was served. This, as far as it not being at a authorized location, in the record, it's noted that is completely false. The actual Secretary of State filing, which is an active filing, by the way, references that the principal executive office for Westside Radiology, the defendant, not this non-party that Spamer works for, is in fact the office where the service occurred. And not only that, and I'd like to address the cross motion as well. I think it's very. I don't think we even need to get there, but if we do, I'm happy to address it. But the point is that although the original service of the defendant was a nullity because it was served a couple of weeks rather, after the plaintiff died, there was no dispute that they actually received it. In fact, we know they received it because they retained counsel shortly thereafter who participated in this motion and the whole aspect of the litigation. But there's no dispute. That was at the same principal executive office as far as the service as the second service of the amended complaint. Again, the description of the individuals not in dispute. They don't contest the fact that the description of the individual was in fact an individual who accepted service as an authorized person on behalf of the defendant, Westside.
They say that person was not authorized to accept service.
I'm sorry?
They say that person was not authorized to accept service.
Well, that's Spamer who says it in a conclusory fashion. He had never any role, responsibility, job, or any affiliation with Westside Radiology other than
I thought they partly owned Westside Radiology.
They acquired certain assets, and it's completely nebulous as far as what type of controlling assets. They had nothing to do with the operation. If you look at the duties and responsibilities that Spamer identifies, they have nothing to do with the defendant, Westside Radiology. They have everything to do with and only to do with the non-party defendant who acquired certain assets, and who knows what it could have. It could have been a desk chair. We don't even know. They don't detail any aspect of what asset was acquired, but any statement relating to anything relating to Westside Radiology is not probative at all because there's no factual predicate as far as knowledge, personal knowledge or otherwise, as to anything to do with Westside Radiology, who's authorized, any agents, employees, or anything like that. They never even conducted a search regarding the name that was identified. It was a first name and it was a description. Spamer's affidavit is completely silent as to any search that they conducted with regard to that. They never even obtained or requested or mentioned any search of Westside Radiology's records. It's all referenced from the perspective, and it's very craftily drafted, but it's referenced from the perspective of this non-party. Spamer has absolutely no knowledge with regard to Westside Radiology,
Thank you.
An active company. Thank you.
Your Honor, I'll be brief. As far as Spamer goes, counsel says he knows that he has no connection to Westside Radiology. He doesn't know that. Mr. Spamer swore in an affidavit that says, I depose and under the penalties of perjury. So he has stated that he has knowledge of that information. So counsel's opinion on that is
I
not...
think it was more so also that Spamer doesn't state how Mid-Rockland Imaging Partners, Inc., how that is affiliated with Westside Radiology.
Well, I'll tell you, the affidavit...
No, but does the affidavit state what the relationship between the two are?
Well, it does state that Mid-Rockland purchased assets of the second corporation, but it doesn't go into detail about having a controlling ownership or anything like that. But that's why, when I wrote my brief, I used the phrase part owner. They're obviously affiliated corporations, and even if they were just affiliated and had no ownership, Mr. Spamer can still speak on behalf of Westside Radiology if they permit him to do so. So counsel's just saying he has no authority to talk and he's just a guy walking down the street. Okay, that's your opinion. I understand the phrase purchase some assets is a little ambiguous. It is, I agree. But
thank you. Thank you both.
Thank you, Your Honor.
State of New York v. Amazon.
Good afternoon, Your Honors. Ryan Feldman, Sheila Baines for Appellant. May it please the Court.
Just wait until everybody's situated. Yes, you may proceed.
Thank you, Your Honor. Let me try to take two important points quickly first, because I think they're easy for the court to decide. The first is the VPC Amazon question. Everyone agrees that stands alone. It's not controlled by the B&H decision and the tax rule there. The entire issue on appeal is whether they've sufficiently established a record for sale for resale. They haven't. There's no testimony from anyone with personal knowledge. All we have to establish from 2011 to 2018, millions of transactions being done the same way, is a contract from 2006 with no evidence that it remained in place, and one of those thousands or millions of agreements without any evidence that it's even representative of the others. This is nowhere close to the conclusive evidence required on a 3211 motion. Maybe it's summary judgment, but they'll put in evidence. It's not there now. To move on to the second issue that I think, although very interesting, can be dealt with swiftly by this court, preclusion. Claim preclusion was the main holding below. Nobody defends it on appeal. Issue preclusion has three triple flaws to it. We have raised them all below. None of them were contested or addressed below. The Mendoza question is very interesting, lots of amicus briefing, but the easy way to resolve this is that this is a purely legal question. If you look at the supplemental record, all of the defendants say that themselves. SR 25, SR 43. The Supreme Court justice says he's importing the legal analysis. It's nothing like issue preclusion cases. All of the cases they cite are about events, a plane crash in Nova Scotia, the late notice in a insurance case, or two private placement transactions in 1999. Issue preclusion doesn't apply. If I could move then to the heart of the case, it's the tax law. We're talking about taxation on instant rebates. And to just set this up, that means if a manufacturer is providing a reimbursement for a drugstore who gives a $2 rebate or discount to the consumer at the point of sale, or a Buick dealer who's giving a $2,000 rebate, or Amazon who's giving a $200 discount, is it taxable? And the tax law says yes to the first two. That's in the record at 614 and 662. But Supreme Court said no to the third. And there's no difference. The test for all three is the tax law. 1101B3. The taxable receipt is the amount received. And the tax department has said this over and over again. I think the easiest place to find this is in publication 838 at page 538 of the record. And to read that, the rule is the amount of a customer rebate or customer incentive provided or reimbursed by a manufacturer is taxable. That decides this case. Those are the instant rebates before.
Is that the way that the B&H case was decided?
That is not the way the B&H case was decided.
If we agree with the B&H holding, does it end it for you here?
No, not necessarily, because the B&H decision was also cited this pass-through obligation, which is not pled in our complaint on page 32 of the record. But the B&H holding was based on a logic primarily that's not even defended here. So the primary, if you look at page 8 of the record, what the Supreme Court justice says is there's no tax because it's not a manufacturer's coupon. That's not even defended. It's counter to all of the precedent in this space. So the defendants offer a different theory. They import not the tax law, but accounting principles and financial presentation principles, and say that if it's a reduction in the cost of goods sold under those principles, it's not subject to taxation. It's very important to understand how broadly that new rule would sweep, because that would mean every instant rebate that happens every day at every car dealership in this state would now all of a sudden not be subject to sales tax. That's not the law. Amazon knew it wasn't the law. Back in 2009, when it became subject to the Amazon laws, taxation in New York, and this is at page 91 to 92 of the record, they investigated that very theory and wrote a memo that we describe, which says, no, in New York, this is taxable. And that's counter to, and the state agrees with us at 475. So they come up with a fallback position, which is neither in the record, as to my prior point, as to fitting this complaint, nor correct. And this position is, if there's no obligation to pass the discount through to the customer for some reason it's not taxable. But that's not what the tax law says. The tax law says you look at what's been received and the total sale. And there's a advisory opinion that's on point. It's TSB A2011S. And it takes this very scenario. There's a reimbursement from the manufacturer, it's cigarettes. Doesn't have to be, in fact, it was not passed through to the customer. Is it taxable? The answer is yes. They rely on 1999 advisory opinion. That is a very complicated, multivariable opinion about lots of different inputs into the discount. If the discount's a function of all of these various inputs, is the discount necessarily taxable? No, it's not necessarily taxable, but the reimbursement always is. And I just want to underscore the damage that would be done by an affirmance here. If this court affirms this decision below, all of a sudden, auto dealers are going to stop collecting sales tax on the instant rebates that happen every time somebody buys or leases a car. And that's a problem not only because it's a change in deduction of the sales tax, but because the 2021 legislation was specifically intended to carve out non-auto sales. And if you affirm the B&H decision, the opposite will be the impact. Let me just explain that. If you affirm the B&H decision, auto dealers will never have to collect sales tax for instant rebates. But the defendants, in the circumstances in the four-part test that's now in the law, will. It's going to carve in non-auto retailers and carve out retailers, which is exactly the opposite of the legislative intent.
Thank you.
May it please the court, William Devaney on behalf of Best Buy, Target, and Adorama.
Could you respond to your friend's that last argument?
Of the impact with respect to autos?
Yeah.
I think it is exactly the opposite, Your Honor. If we take a look at the TSB to which my friend was referring to, it focuses on the sale price because that's the definition of the receipt. The sale price, whether received in money or otherwise. And if we take a look at the department's guidance with respect to automobiles, it says, the guide states that sales tax should be charged on the amount of a customer rebate or customer incentive provided or reimbursed by the manufacturer or any third party that is applied against the amount due under the sales agreement. So you focus on the price that's stated on the sticker price, the price that's negotiated between the dealer or the retailer and the customer. With instant savings, for example, that price has already been reduced. It's a store-wide sale, right? The reduction that's provided to the retailer from the manufacturer, it's up to the retailer whether or not they want to mark it down. If they mark it down, it is tantamount to a store-wide sale. When we walk into a store and we see an item on sale, we don't expect to pay income tax or sales tax on the prior price. We pay it on the sale price. But that automotive TSB goes on to make clear that for these purposes, meaning for sales tax purposes, rebates and incentives do not include factory to dealer rebates or other incentives which reduce the dealer's cost of the vehicle. And again, coming back, instant savings are a reduction in the cost of goods sold. It's exactly the same as that which reduces the dealer's cost of the vehicle. And the very TSB my friend points to supports the position that instant savings, which are directed from manufacturer to retailer to reduce the cost of the goods sold, are not subject to sales tax. My friend also puts many of his eggs, he cites to the Zawowski case 6 times. He cited to the TSB we were just discussing 7 times. Zawowski is another excellent example of how this works. In Zawowski, Mrs. Zawowski negotiated, she signed a receipt, she negotiated a $23,000 price for a car. That was the sticker price on the car, was $23,000. Ms. Savowski then applied a GM rebate as well as credit card points to the car, but the sticker price of that car never changed. She gave the rebate and the credit card points as consideration. And that's another huge difference, right? Instant savings are not consideration for the sale. Instant savings, as I mentioned, are a reduction in the cost of goods sold, which is consistent with the treatment, the accounting treatment for financial reporting purposes under GAAP. It's consistent with income tax treatment under the IRS. And with respect to Best Buy, they had an opinion from PwC saying that instant savings was not subject to sales tax in New York. So if you go back to Savowski, sticker price, the sale price, when we look at the definition of receipt, remained $23,000.
And you're paying the sales tax on the $23,000.
I'm sorry, Your Honor?
You're paying the sales tax on the $23,000.
Correct, Your Honor, right? Because the rebate and the credit card points go toward consideration for the price of the car. The sine qua non, the relator tries to bundle all of this and equate it to coupons and equate it to rebates. But with respect to a coupon, those are physical things. As the trial court noted, they're negotiable instruments.
Well, they're now digital.
They can be digital, Your Honor, but they function the same way. Here's the price, I have a coupon, price comes down, right? Similar to a rebate. They're part of the, price, here's the sale price, price comes down.
And you're paying the tax on the price that comes, what it goes down.
You're paying, correct. You're paying, that's absolutely correct. I see, Your Honors, that I'm out of time. If the court has any other questions, I'm happy to answer them.
Thank you.
Thank you very much.
Kelly Moore from Morgan Lewis, simply here to introduce my colleague, Will Peterson, who's been admitted pro hoc vitae, and he'll be arguing on behalf of Amazon.
Yes, proceed.
Thank you. May it please the court. William Peterson on behalf of the Amazon respondents. Mr. Devaney's arguments about the merits of the taxability of instant savings programs apply equally to Amazon's instant savings programs, and obviously we've adopted those arguments as well. There's an independent ground to affirm, of course, and that's collateral estoppel from the B&H decision. This court can either address the merits and not collateral estoppel and not the merits, or both, in order to affirm. I'll also speak.
That answers my original question, which is if we go with the B&H ruling, if we agree with that, that's all we need to do. We don't need to really address Mendoza and collateral estoppel.
Absolutely, Your Honor. We're happy for an affirmance on either ground that you'd like to give us one. Supreme Court agreed with us both on the merits and on collateral estoppel, so this court could certainly do so as well. My friend's argument about collateral estoppel suggests that this is a pure question of law. That is incorrect. This is absolutely a mixed question of law and fact, because what we're relying on is the application of the tax laws to the instant savings program at issue in B&H, which is factually indistinguishable from the instant savings programs at issue here. So this is not a case where parties trying to take a ruling about the meaning or interpretation of a statute and import it into a completely different factual context. That's what the pure question of law exception is intended for. You see that in the American Home Assurance Company case that my friend relies on. There, the abstract question of law was whether an excess carrier must make a showing of actual prejudice when it seeks to avoid coverage obligations. But there was a mixed question of law and fact there, you see in a footnote, and the mixed question was the untimeliness of the notice defendants actually received. So it's the same thing here. We're not asking to take a legal ruling from B&H and apply it here. We're asking to take the analysis of how the tax laws apply to the factual situation of B&H and apply that to the factual programs here.
So in terms of Amazon, what evidence did you present concerning the inventory, the invoices for that period of time? I think it's 2011 to 2016.
That's with respect to the vendor-powered coupons. They're a separate program that we have.
So why shouldn't that cause of action be restored?
Right.
Well, Your Honor, let me first frame this by pointing out how little there is alleged about vendor-powered coupons. You will find one sentence in the amended complaint making factual allegations about them. Here it is. In 2011, Amazon rolled out new manufacturer-funded product called vendor-powered coupons, or VPCs. That's R39, paragraph 77. That is the entire set of factual allegations about VPCs in the complaint. Nothing about who paid them, nothing about which entity received them, nothing about which entity contracted to receive them. What the evidence that we presented, and you see the agreement between Amazon.com LLC and Amazon Fulfillment, that's record 1205, shows the
Their
relationship.
point is that you presented it for just 1 year, and it's covering many years.
Well, we have the affidavit of our expert who talked about the corporate structure over the period of time. That's Mr. Pomp. You see his particular discussion of the corporate structure on record 163. His affidavit is found on pages 153 to 171. And fundamentally here, it's just not in dispute. My friend has not made an allegation and could not make an allegation in good faith that these VPCs were paid to anyone other than Amazon Fulfillment. The only evidence, the only allegation here is what we have shown. We did not specifically say this corporate structure existed in exactly the same way until 2018 outside the affidavit of Mr. Pomp, but it's not open to debate. And critically, there is no allegation to the contrary. There is simply nothing alleged in the amended complaint that suggests that there was any wrongdoing with respect to VPCs, particularly with the suggestion that we might have been paying them to the wrong corporate party. Let me touch briefly on the Mendoza exception for collateral estoppel. I agree you don't need to reach it here, and the easiest way of not reaching it is twofold. First, to say it hasn't been adopted as a matter of New York law, and in fact, New York cases have applied collateral estoppel against the state. And second, no case that we have found ever has extended the Mendoza exception to a private qui-tam relator. The Fifth Circuit in United States ex rel. Gage versus Rolls-Royce did, in fact, apply collateral estoppel to a private qui-tam relator under federal law, even though, as a matter of federal law, collateral estoppel wouldn't be applied to the federal government itself. So you would be the first court to say that a private relator can take advantage of this special rule that applies only to the government. I'll also point you to the Supreme Court Eisenstein versus City of New York, which distinguishes for purposes of federal law between cases in which you have a private qui-tam relator who is asserting claims on behalf of the federal government and cases in which the government is itself a party and doesn't allow the private qui-tam relator to take advantage of special rules applicable to the government. Thank you.
Thank you.
If I may start where I ended, they're not disagreeing.
Actually, could you respond in terms of Amazon?
What was just made about the...
Yes.
Yeah, there was no need for us to allege the elements of their affirmative defense in our complaint, and the court doesn't need to take their word for how
He says there's just one sentence on the subject. Why is that one sentence enough?
Because the allegation is that a general practice for manufacturer-funded discounts, which included VPCs and the instant rebates, they were violating New York law. And they made the affirmative defense that for VPCs, we have a separate defense. And it was a sale for resale. And the idea that we couldn't in good faith contest what they've in a threadbare fashion put in the record is wrong. There's no sale for resale certificate, which is required by New York law. And there's every reason to believe that this is not what happened, given the very thin record. To go back to the point about auto dealers, I need to make a few things clear. One is that they were not contesting what I said, which is that for instant rebates, it will no longer be the case that the instant rebates will be taxed. The distinction in at the publication 538 from factory dealer incentives is about inventory. And there's a distinction. Every car on the lot, there might be a price adjustment. That price adjustment is not taxed. That's what a factory to dealer incentive is. A factory to customer incentives is the trigger by the sale, and that's how sales tax works. The statute says if it's because of the sale, right, the taxable receipt because of the sale, then you have sales tax. And the reason they're fighting the coupons is because, contrary to what they said up here, C1 and C2 and C4 make very clear that the total receipt is what's taxed. What we're talking about here, just to be very clear, is Amazon and Best Buy will show you the original $1,000 price, and we'll say instant savings of $200. The $1,000 needs to be taxed. In the coupon example, there's no different law for coupons. It's the same statute.
So I'm paying $200. I should be taxed. I should pay the taxes on $1,000.
If you're paying $800, you're taxed on $1,000. That's what every authority says, including explicitly the coupon regulations, which is why they're fighting it. There's not a different rule for coupons. It's the same law. This has been the law since the late 1970s in New York. They knew it. They did the research. Their own internal documents say so.
Thank you all.
Thank you.
People v. Gustavo Gilon. Yes.
May I proceed? Thank you, Your Honor. Good afternoon. Taylor Poore with the Office of the Appellate Defender for Mr. Gilon.
So, as a threshold matter, the people concede that based upon People v. Castillo, we have the conviction has to be reversed and there has to be a new trial.
Yes. There actually should not be a new trial at all with regard to Mr. Gilon because, and the indictment should be dismissed, which is the only issue remaining for this court to consider because there was absolutely no evidence that Mr. Gilon shared Castillo's intent to fire at LeBron. First of all, it's undisputed that it was Castillo, not Mr. Gilon, who fired at LeBron. Mr. Gilon was not there. There was no evidence that Mr. Gilon told Castillo to kill LeBron. There was, in fact, extremely good reason to believe that Mr. Castillo fired at Mr. LeBron in self-defense, as the Court of Appeals agreed. LeBron, and you can see this on the surveillance footage, he came into the salon after Castillo. He's a bigger
the blade on his neck. We saw it.
Right, and so the reason that's relevant here is that all of the circumstances that make it more likely that Castillo fired in self-defense, all of those circumstances make it more likely that he acted unilaterally, which means that Mr. Gilon had nothing unilaterally, independently of Mr. Gilon, and that Mr. Gilon had nothing to do.
So there was no circumstantial evidence in terms of the phone calls. I forget how many phone calls there were between the two. That Mr. Gilon, solicited Castillo to kill LeBron?
So as to those phone calls, the law is crystal clear that without any evidence about their content, they are insufficient to establish shared intent, and I refer the court specifically to People versus Rivera, which is cited in our opening.
By themselves, they don't establish that he shared the intent, but that's not all there is. I mean, there's Ramos who testifies that the defendant wanted LeBron dead.
And that Ramos refused to commit the murder. There's defendant's prior statements about, as my colleague stated, about wanting LeBron to be dead. Calls to Castillo after Ramos refused to kill LeBron.
Just to correct a couple of things.
The defendant flees under circumstances. I know it's weak evidence, but consciousness of guilt. He flees to New Jersey.
So could I absolutely, and I want to respond to all of these factual pieces. First of all, even crediting Ramos's testimony, which we don't think any reasonable fact finder could do, it doesn't help. Ramos is, first of all, he doesn't refuse to help in this alleged offer.
He didn't refuse to commit the murder?
He didn't refuse. He says he's equivocal about it. So, but according to his own testimony, Mr. Gilon has supposedly hired and paid him with cocaine to do this hit. Even if you believe everything he says, first of all, that's not enough because the prosecution had to prove shared intent with Mr. Castillo. And second, believing what Ramos said makes it less likely that then Mr. Gilon, who supposedly, according to what Ramos has just said, hired him and paid him for this hit, then calls a totally different man for the same hit. It doesn't make any sense.
He calls the different man when Ramos says no.
Ramos does not say no. And that is clear from his testimony. Additionally,
Ramos agreed to commit the murder?
He doesn't. He says that he takes the cocaine as payment. He doesn't affirmatively. He kind of leaves the question.
But he also doesn't say yes.
But if this is something that, I mean, if supposedly, if this conversation happened, it makes it less likely that Mr. Gilon then calls somebody totally different for the hit. Either way, take into account what then happens, right? So the intervening events, Castillo comes into the salon and Mr. LeBron comes rushing in after him, charging in after him, and then holds a razor blade to his face. I mean, under those circumstances, the fact that this is, the idea that this is something that Mr. Guillen has orchestrated is
That's what
just
got
the
you
realm of
That's what
speculation.
got you the justification charge, right?
Well, we
I
didn't
mean,
get the justification charge, but
that was the
that's the
basis
issue.
for the justification. That
But
was
there-
one of the issues.
But
Right, the reversal, right, is because based upon all of the interactions between the two, that there should have been between the defendant and LeBron, that there should have been a justification.
But any speculation that the calls between Mr. Castillo and Mr. Guillen involved an attempt to specifically ask him to kill LeBron was pure speculation, and that is completely
Well,
impermissible.
no,
as a
that's
basis
the
for-
whole point. The point is that it's cumulative, right? We're not talking about any isolated. We're not talking about anything in isolation. We're talking about cumulatively in terms of the circumstantial evidence and whether, based upon that, the jury could have found.
And could I just respond specifically to that, Judge? So consider consider the circumstances at trial. All of the evidence at trial is that Mr. Guillen has spent multiple days trying to mediate a dispute between Castillo and LeBron, who are 3 longtime friends. So he is trying to. If we're sitting here speculating about the contents of that call, the most likely thing he said was, "This guy is sitting outside my salon. He's been here all day. He's bugging my wife. Get over here and pay him what you owe him," as he's been asking for both of us for days now. That is the most reasonable thing
How
he
is
said
he
on the call.
trying to mediate a dispute where he actually states to Ramos that he wants LeBron killed?
Ramos.
I mean,
is
that's
the
not
only,
good for mediation.
So Ramos is the only witness who ever suggests that Mr. Guillen has any interest whatsoever in wanting LeBron
But
dead.
isn't LeBron both angry at your client and
So it's clear
Castillo?
from the only objective, credible testimony, which comes from the other witnesses, specifically Danny Garcia, Castillo is the one who owes LeBron money. They've all been friends for a very long time. So LeBron is clearly asking Mr. Guillen to help him get the money
But
back
the
from
threats are
Castillo.
being made against Mr. Guillen's wife, right?
Yes, and Mr. Guillen.
And Mr. Guillen,
LeBron, absolutely, LeBron has
family.
been aggressive to all of these people. And every sign is that Mr. Guillen is trying to de-escalate. He's saying, just give us some more time. I am sure that I can get Mr. Castillo to give you your money. That is what the evidence is. And so the speculating that anything else happened in that call is
I think that's
impermissible.
one view of the evidence. The issue is whether or not there's another view of the evidence which the jury considered in finding the defendant guilty. But you have time on rebuttal.
Good afternoon. May it please the court. Cynthia Carlson for the Office of Darcel D. Clark. The defendant's conviction for manslaughter in the first degree should be affirmed. The evidence at trial established beyond...
Should be affirmed. I thought you conceded.
Excuse me, I apologize. The indictment should not be dismissed. I apologize. Thank you, Your Honors. The evidence at trial established beyond a reasonable doubt that the defendant committed first-degree murder. Ramos testified that the defendant is the one that said he wanted the victim eliminated. And Ramos, like Your Honors noted, did not agree. He said that he demurred and wanted to get out of there. And how we know that...
He did accept payment.
He accepted to start. For a start is how a defendant offers the drugs to Mr. Ramos. Mr. Ramos says, okay, let's talk about this later. And defendant then gets him to give him his number and he calls him. We know Ramos's testimony is accurate about that because we have the phone records that back up that this phone call occurred. The only person that was receiving phone calls from the victim on the day of the shooting is the defendant.
You received a lot of them, right? 32?
32 phone calls, 19 of which happened before the YouTube fight was even recorded. The fight is with Castillo, and we know that while we don't know the specifics the fight is with Guillen. While we don't know the specifics of the conversations between Guillen and Castillo, what we do know are the number and the timing and what happens after those phone calls are made. The very first phone call that the defendant makes after he is in an angry phone call with LeBron, he calls Castillo, and Castillo then starts to move from northern Manhattan to the western portion of the Bronx. If Your Honors have no further questions, the people will rest on our brief and ask you to remit this case back for a trial. I would also just note, just to clarify, the Court of Appeals and this court the Court of Appeals said that the charge should be given for justification, but another panel of this court found that the evidence was overwhelming to disprove justification. So that's why there's not this independent act in between the solicitation and the actual murder.
Thank you.
Thank you.
Just like to make 3 very brief points. First, everything that my adversary just described in terms of what happened over the course of this day and the communications between Castillo and Mr. Gilon are entirely consistent with what I would argue is the much more plausible speculation. Again, we're in the realm of speculation about their communication. Get over here. This guy keeps saying he's not, you need to pay him what you owe him. He's bothering me now. And that is absolutely not in
line between speculation and inference.
It's according to People versus Rivera that without any information about the conversation, speculation is impermissible. And it's pure speculation. We have no information about the content.
Well, I agree
Second,
with you if you just take the phone call in and of itself, but when you put it in context, like your adversary just did, I think it may lead to an inference.
so I would.
Permissible one.
I also wanted to point out briefly that Ramos's testimony about the phone call, and I addressed this in my reply brief, like everything else he talked about, changed every time he addressed it. So I think that saying that that's corroborative is a stretch. Finally, I didn't get a chance to address the consciousness of guilt question from the opening argument. The trial testimony was that Mr. Gilon wanted to stay on the scene, and that it was his wife, Ms. Garcia, who said, "You're on probation. You need to get out of here," and that he only left the scene because she ordered him to. So I think
She ordered him to.
she told him to. She told him, "Get out of here. You're on probation."
It's
It's not a
one
great
thing.
decision.
It's one thing
It's
to
obviously
leave the
not a great
scene,
decision.
It's another thing to leave the state, right?
Well, I think once he had left the scene, I mean, I think that's
In the next,
She told him
it's a
leave
difficult
forever.
thing to
She told him leave forever.
get
Don't
out
come
of
back.
here. Yeah.
Yeah, get out. Go to New
It's
Jersey.
he's in a realm
When
of
he sees the police, he flees.
yes, and I think
Attempts
that
to
that's he's already left the scene at her persuasion. I think that at the very least that completely.
At his arrest in Fort Lee.
I'm sorry.
At his arrest in Fort Lee, when the police are
Right.
confronting
Yes.
him,
Yes.
He flees again.
Yes. At that point, he's left the scene. But I would say that it has nothing to do with consciousness of guilt. Thank you, Your Honor.
both. Barbara v. Roman Catholic, Archdiocese of New York, Roman Catholic. Roman Catholic. Justice Kapnick is recused on this matter. Oh, mine says that. Nervous.
Good afternoon. May it please the court. Justin Gardner for the defendant appellant, Roman Catholic Archdiocese of New York. I'd like to thank you for granting the application for oral argument on this case. I will be brief because I have only one significant point that I believe should be pointed out to this court. With respect to the confidential mediation program and the records of that program, there were 5 claimants pertaining to the priest in issue, Herman Heidi. Of those 5 claimants, 3 of those claims were submitted after the August 14th, 2019 effective date of the Child Victim Act. And I would ask the court to consider, after there is already a Child Victim Act and 3 of these claimants could have filed actions under the CVA, they could have done it under a pseudonym with the protection of a confidentiality order and gotten the same protection that the claimants in this litigation could have, but they chose to pursue the IRCP program to settle their cases. And I cannot imagine any reason why a claimant would do that other than that they would not want to be interviewed or have to discuss the traumatic events that they believe that they suffered through.
All day now, we've been dealing with speculation. We cannot speculate as to why they would choose one avenue as opposed to the other avenue. So I don't know why they would do so, and nor do you. It would be speculation. The IRCP, that states specifically that your information may be shared with others. In particular, it may be shared with law enforcement. So I know one of your arguments, it was the confidentiality issue, but when they signed on to that program and when they chose that particular avenue, they were aware that their information could be shared.
Understood, but sharing it with law enforcement is much different than sharing it with plaintiff's counsel and being
It
subjected to
doesn't mean that they have to speak to plaintiff's counsel.
They could be subpoenaed to give deposition testimony or at trial. The other courts that have dealt with this issue, both Harmon and Melfi, permitted the redaction. In fact, Melfi versus the Roman Catholic Archdiocese of Albany directed the redaction of the identifying information, specifically the names, in ordering the production of those documents.
I think we've dealt with this as well. McNary, we dealt with this as well, in terms of redacting the information, in terms of the redaction of the information.
McNerney dealt with a direction to produce the documents because they may lead to the discovery of admissible evidence as to constructive notice, even though the documents post-dated the abuse and issue. I don't believe McNerney addressed whether the victim's name should or should not be redacted.
I think we also discussed in McNary, however, the fact that it could be redacted.
I don't specifically recall that from the case, but the main point of my argument here today is, to the extent that the court orders these confidential mediation records produced, we would ask that they would be redacted as to the identifying information of the claimants, and specifically on the basis that those claimants could have brought litigation, at least 3 of them, and chose not to, that the burden has not been met to show that there's any information needed from them that couldn't be gleaned from the 5 members who testified concerning abuse in this grouping of cases. The court below ordered the records produced on the basis of modus operandi evidence. So while we disagreed that that was pertinent to this case, the modus operandi of this particular alleged abuser can be developed through the litigant's own testimony, and there's 5 of them. In fact, there were 2 cases added to the Herman Heide grouping subsequent to this appeal, so there are actually 7.
And so again, we've stated that it is the plaintiff may be able to glean certain information or additional information from the information to be imparted to them. So it's up to the plaintiff to make that determination as to whether there's additional individuals or evidence which they would be able to secure. But thank you.
Good afternoon. May it please the court. I'm Diane Palicelli of Phillips & Palicelli. I represent one of the plaintiffs, PC2 Doe, but I'm here to argue on behalf of all of the plaintiffs in this consolidated grouping, the first name of which is Barber. I'll be very brief, Your Honors. Basically, this is a discovery motion. It's a discovery decision, and the Supreme Court below did not abuse its discretion, and she very, very carefully laid out in a long, lengthy opinion why these documents were relevant. And if I can quote one particular line, she goes through all of the individuals who were abused by the same priest, and she says that it's hard to understand how the Archdiocese can assert that this is irrelevant when it's the same conduct by the same abuser during the same period of time, in the same fashion. These individuals are notice and fact witnesses. Some of them—
So relevancy aside, how do you respond to your adversary's argument that these victims don't want to be known? They want to remain anonymous or not interfered or bothered with?
Again, that is speculation. We're talking, first of all, about discovery only, what information they may or may not have. We're not talking about subpoenaing to trial for testimony.
There's also a standing order with regards to what you can do with this information, correct?
There is a confidentiality order that clearly says you can limit the information to this case. This is not for public dissemination. It's limited to this case. And interestingly, Justice Krauss also noticed that in looking at this document, and I'm quoting again, page 6 of her decision, some of the alleged individuals wrote to the church looking for the names of other victims or students who have also undergone abuse. These people, or at least some of the ones that Justice Krause was referring to, actually want to help others. So there should be, not only is it speculation to assume these individuals don't want to come forward, but there's actually reason to believe they may well want to. And no one's going to force anyone to do what they don't want to do. They could just say they don't know, they don't understand. But these individuals are actually maybe able to say, yes, I saw Father Heidi do this to plaintiff Barber, or I saw Father Heidi do this to PC Doe, or I saw the reaction, or I reported this in 1963 to my teacher or what have you. They have critical information to notice, as well as Justice Krause pointed out, they have critical information on other issues because notice is not the only issue in this case. The Archdiocese is denying that these individuals were abused. They're denying that they employed Heidi. They're denying that they had control over the school and could have done anything to prevent this. These individuals who were there again at the same time in the same place may well have information or likely to have information that can shed light on all of that. Or to point to other witnesses who were there, who, again, those witnesses could shed light. So, again, it's discovery. This is, Justice Krause found that this was reasonable material and necessary information. She reviewed it painstakingly, decided which documents she would allow to be produced, and some she didn't allow to be produced. This is what discovery courts do. And, we maintain that she did not abuse her discretion and that the decision should be upheld.
Thank you.
I'll respond with one brief point. To the extent the court agrees with the lower court's decision as to the relevance and orders the production of these particular documents, I would reemphasize that they should be redacted as to the identity. The contents of the documents themselves would contain anything that plaintiffs could possibly need to pursue this case in discovery. Counsel mentioned that some of abuse victims might want to be helpful. And I would note that counsel for the plaintiff, Vincent Kennedy, in this grouping, in fact, represented 2 of the IRCP claimants. And if, in fact, they wanted to be helpful and have their name out there and be part to help in the litigation, it could have contacted their client or former client, asked, and disclosed them as witnesses in this case. But they haven't done that. They're asking the Archdiocese to reveal the names of these people when the Archdiocese promised them that they would not if they participated in this program, other than to the District Attorney's Office.
Thank you. Thank you, Bob. Last case for argument, St. Mark's World Acquisitions, LLC versus Dr. Michael Morgan. Yes, whenever you're ready.
May it please the court. Good afternoon, Your Honors. My name is William E. Bokwe. I represent Dr. Morgan. We do appreciate the opportunity to argue this, as this was an enumerated case, and it was filed pro se. So I'll do my best to try and focus on what I believe Dr. Morgan's strongest arguments are here.
You filed a notice of appearance?
I did, Your Honor. I did it through NICEF, as well as I did also
okay.
write one and hand it up. Specifically, we're dealing with a so-ordered stipulation from 2019. And part of the stipulation had issues that were to be dealt with in arbitration, and part of the stipulation had issues that were already agreed to. I believe Dr. Morgan's strongest arguments here is that this is a merger and acquisition that occurred in 2016, 2017. The stipulation required for there to be a final audit of the company so that Dr. Morgan can be paid his final purchase price.
The order to quit.
Well, and that's the issue, right? Is that we are here in 2025, and still the plaintiffs in this case have not done anything to try and comply with Section A1 and A2 of this order to finalize this purchase. And Dr. Morgan is significantly prejudiced. It was so ordered, and the evidence that was submitted to the lower court which I don't believe the trial court reviewed Dr. Morgan's request for sanctions.
It was supposed to be an audit, an independent audit. What's happened with that audit?
Well, specifically, the emails and the evidence that have been provided was that both parties agreed, as was stated in the stipulation.
Seth Marin.
Seth Marin.
But he's pulled out. So what's happened since then?
Yeah.
Dr. Morgan has done his part of the stipulation, which is if Seth Marin.
Has it been his position that he's entitled to pick on his own, pick the substitute independent auditor?
As it states within the stipulation, that is correct. Because 5 days after Seth Marin.
What in that stipulation gives him the sole right to determine the auditor? What language do you point to?
I will go to it. Section A1 states that if Seth Marin declines to serve as an independent auditor, acquisition, the plaintiffs will propose 3 independent auditors, alternative auditors in writing within 5 business days who had no relationship with either party. They have not done that, nor have they provided any evidence in their opposition to Dr. Morgan's motions that they did so.
Does that apply here? Because the auditor didn't decline, the auditor just withdrew.
Well, to be more specific, if you do read the emails, the auditor proposed a alternative way to audit the business. He asked both parties if they were okay with that. Dr. Morgan agreed to it. Dr. Morgan reached out to Mr. Marin. Seth Marin informed him he has not heard from the plaintiffs. It persisted to the point that Mr. Marin said he couldn't complete it without getting this agreement. So per the stipulation, if he declines, regardless of the reason, it goes to the next step. They get to propose 3 auditors, which they didn't. What Dr. Morgan has done is he's taken the next step, which according to the stipulation says if acquisition fails to propose 3 independent auditors within 5 business days, then Dr. Morgan shall have the sole right to designate an independent auditor.
Why did Marin pull out? What prompted Marin to pull out?
Per his emails that I have here, Marin indicated January 8th of 2020.
He said it was based upon the inadequacy or the inability to form an opinion on the statements for the year ended December 31, 2016.
I believe specifically it was an issue with how he would audit the business. And specifically, he stated, I'm recommending that instead of spending more time on the audit, we change the level of service called agreed upon procedure. We can discuss in more detail, however, the high level LLP would perform certain procedures. And not to go into all the detail, but he proposed a way of going forward to both parties. And
no, but the point, the issue is why, if the auditor pulled out, why does that mean that they violated the stipulation?
Because the stipulation says so. If it's pretty clear that
so they would be responsible for Marin withdrawing?
Marin declined, and per the stipulation, yes, and I would say that they were responsible because in their own deposition, which happened later, one of the defendants actually said, we didn't want to go with Marin. And while it's not before the court, it's clear they didn't want to go with Marin.
Not in the record. I didn't see anything in the record about it.
It's not in the record, but I think what's glaring here is that the defendants have done nothing to move this provision forward. Dr. Morgan sits without receiving his full compensation for his business. Dr. Morgan simply wants this to move forward. And considering...
Okay, so we'll hear from them. Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors, and may it please the court. Lane Feldman on behalf of respondents. I'd like to...
Once Marin pulls out, that's it? There's no obligation to do anything else with regards to appraising this business?
So I want to make it clear that Mr. Marin did attempt to audit the business for a year, and respondents complied with everything that Mr. Marin asked for. It was the fact that the pre-acquisition books and records of the business were inadequate because there was strong evidence of commingling of funds by Dr. Morgan that rendered Mr. Marin unable to complete
That was the
audit.
reason for my question. I was wondering what caused Marin to pull out, because I did see something in the record concerning Dr. Morgan not signing, I think, the 2017 tax return or some other issues in terms of the financials that he provided.
I just want to clarify, so.
What's happened to the audit since then?
Sure. So Seth Marin did propose this alternative procedure called agreed upon procedures, which when I deposed Mr. Marin, he testified is not an audit. My clients didn't respond to that offer because it's not an audit. And though counsel has suggested that Dr. Morgan agreed to that agreed upon procedure, there is no evidence in the record of that happening. What happened instead is that Dr. Morgan proposed his personal accountant to audit the business. And because the records were actually unable to be audited because information was missing from the pre-acquisition time period, it doesn't matter if Mr. Marin audits the business, if Dr. Morgan's preferred auditor audits the business. An auditor can't audit things that don't exist.
So where do we stand now?
So there is a 2021 case pending before the Supreme Court in which Dr. Morgan has alleged that the respondents breached this very same stipulation of settlement for the very same reasons, alleging that they failed to comply with the audit, which is contradicted by evidence, and that the audit should go forward. This contempt motion, which also seeks to void the stipulation, the very stipulation that we're here talking about, the lower court properly found is not the appropriate mechanism or venue to adjudicate this dispute, which is still pending before another court in the Supreme Court. And that the docket on that one is 651186-2021. These same issues are also before the court in a 2021 case before the 2020 case before the Supreme Court. They were also before the Southern District, and that went up on appeal to the Second Circuit, and the Second Circuit recently found that the claims there, which are the exact same claims that are part of this contempt motion, were barred by res judicata. So Dr. Morgan here has tried to shoehorn what is essentially an ongoing, pending, unadjudicated breach of contract claim into a contempt motion in this litigation that has been closed by virtue of a final arbitration award being entered and a judgment being entered in his favor. Without any other questions, I'll yield my time. Thank you.
Thank you.
I'll just touch on a few things because I think that what has been happening, and I will admit that Dr. Morgan has proceeded pro se, and for that reason, there are some different litigation going on. The federal case has nothing to do with this. The 2020 case actually doesn't overlap, and respondents did not provide anything to the court because it doesn't. And specifically in the 2021 case, which the respondents argue, they were in that case arguing before the court, and there was a specific provision, cause of action in that particular case, and it was simply, in 2021, the cause of action is requesting for the respondents to pay the independent auditor that he has provided.
Was that his personal accountant?
No, but he had the sole right to pick it. It's not his personal accountant. Per the stipulation, he has the sole right to pick the auditor where the respondents have done nothing. Now, counsel in that case told the court in regards to that particular issue, and this is from the transcript, and it states, so Mr. Morgan has one cause of action in this case in paragraph 46 of his amended complaint, which was filed a month after this motion. And it sets forth the relief that he's seeking and the declaratory judgment that he wants. And it's declaratory judgment ordering defendants to advance the independent auditor's cause and deduct from the final purchase price in accordance with paragraph 3 of the stipulation ordering defendants to provide information regarding the SBA loan going on. He is not, as far as I can tell, seeking a valuation of the company. None of this has anything to do with the negotiations regarding the purchase of the company. This is all post-stipulation things. So when Dr. Morgan says this whole case is about calculating the EBITDA of the company, maybe, but that's not what is set forth in his only cause of action here, which doesn't mention anything about the value of the EBITDA. And before the court were even to get to that, the court would have to find that another audit would need to take place. And that finding has not even occurred yet. And so they have admitted that this EBITDA, this audit has not occurred. And the specific relief in this particular court where the stipulation was entered, and he has sought a motion in the court where the stipulation was entered to get the respondents to do what they're supposed to do and value this company, which 6 years he's been sitting and he hasn't gotten paid. And all he's seeking for is to force them to do what they're supposed to do. And he submitted a lot of emails to show the interactions with Seth Marin and that he did what he was supposed to do to try and comply with it. And because the respondents still have done nothing to provide 3 additional auditors of their choice that they can comply with, he's in limbo.
Thank you.
Thank you, Your Honors.